Thank you, Judge. Yes, I have had a chance to review the PSI and the recommendations with Mr. Gaya.
Do you have any additions or corrections?
I just have some minor additions, I perhaps would be the best way to say that.
Go ahead.
On page 1 of the basic information sheet, it does not list any monthly income of $75 and up. Mr. Gaya does have 2 jobs and makes approximately $600 a week. So I wanted that to be reflected because restitution is a large part of the sentencing conclusion of the case. Sure. Later on, it does.
Okay, in the employment on page 7, it does include some employment information.
Yes, that's correct.
And then on the basic information report, however, it said monthly income of $75 and up, it said no. So Agent Young, can you just put in some information on that basic information report consistent with the employment section of the PSI?
Yes.
Anything else, Mr. Steffen?
Thank you, Judge. And then on page 1 of the evaluation plan, it was Mr. Gaya's understanding that his salary was $1,500 a week, not $875. So that could just be an addition, not a correction. There's a disagreement on that.
Well, that comes from the description of the offense narrative. And Agent Young, I imagine you got that from police reports in the matter?
Yes.
Okay. So, I mean, that's what was reported. I mean, I suppose if we want to have a hearing over whether it was $875 or $1,500, we can get the officer in here.
I don't think that's necessary, Judge. Okay. Thank you.
Okay. Any other?
Other than that, I don't have any factual corrections nor objections.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. So far, what might seem like routine paperwork is actually laying the foundation for the entire sentencing decision. Every number, every correction, and every objection can affect the defendant's guideline range, restitution obligations, and ultimately how much freedom or jail time is on the line. But here's where this hearing takes a dramatic turn. The prosecutor is about to challenge several scoring decisions that could significantly increase the recommended sentence. Will the defense keep the guidelines low? Or will the prosecution convince the judge that this case deserves a much harsher outcome? Keep watching because the biggest legal battles are just beginning.
Okay, and Mr. Juliet, the advisory guidelines are scored at 0 to 17 months on both counts being forgery. Any additions, corrections, or scoring challenges from the people?
No additions, corrections, but I do have a few scoring challenges.
Okay, go ahead.
Looking at PRV 4 and 5, and applying the 10-year gap rule, it looks like his most recent conviction was 4/29/2011 with a discharge date of 11/15/2011. Then he had an offense in 2015 that was dismissed. The commission date of this offense was around July of 2023, so I think PRV 4 and 5 can be scored under the 10-year gap rule.
Mr. Steffi?
1 second, Judge. Aware that we're going to have a challenge here, so I could just need a minute to look into that.
Yeah, it would inure to your favor. So the prosecutor's making an objection.
And that does not change the PRV level, Your Honor.
Okay. Agent Young, did you have any information about an intervening?
No, Your Honor, I'd have to agree with the prosecution.
Okay.
I would just note, Judge, that the 2013 offense, which was an arrest date of, it's number 2 on the marijuana possession, that was dismissed. I don't know exactly which method that was.
Yeah, because that would be the only thing. If it was a dismissal per a 7411, that would count as a prior conviction for scoring purposes, right?
That's my understanding.
It's 7411, I believe that's correct.
Well, I don't know. Is it on HIDA? It is.
I believe it's HIDA or 7411, I think counts. Like,
That was in the 89th District Court. Does Mr. Guyette recall what happened with that?
It was a dismissal on completion of the drug test.
did you have like a period of time on probation?
No probation, nothing. It was if I showed up, it was even just a pre-trial or.
Okay. Okay, well, we'll score PRV 4 and 5 at 0 points. And then, so the total PRV is 10 points. And that still is level C?
Correct.
Okay. So it's still, it doesn't change the guidelines, but we'll score PRV 4 and 5 at 0 points.
And then I have 2 OB objections.
Okay, go ahead.
I'll start with OB 16. It's currently scored at 5 points. Under OB 16, 10 points should be scored if the property had a value of $20,000 or more. Likewise, MCL 777.46, subsection 2, subsection A, allows the court to aggregate the amount lost. In this case, I believe it's $166,000, and the court can score 10 points based on the aggregate value, even for uncharged offenses or charges that were dismissed. So I believe that should be scored at 10 points.
Mr. Stephan?
Thank you, Judge. One moment, please. Just got my guidelines guide. Judge, I don't have an objection. The total value alleged was more than $20,000 in this case.
Okay, so that would be 10 points in OB 16 rather than 5. Mr. Julia?
And that would raise it to 35. And then my final objection is OB 4, psychological injury to a victim. I don't know if the court wants to hear the victim impact statement before making a ruling on that. But it's my understanding the court is in possession of the victim impact statement. It's my understanding the victim was going to read directly from that, so I can make argument now or after the statement.
So the victim's going to read the statement?
Correct.
Mr. Steffi, have you had a chance to review that victim impact statement?
I have, Judge.
Any argument you wish to make about whether its contents would support a scoring of OB4?
Yes, Judge. I don't think I recognize the severity of the offense and its impact upon the victim. However, I don't believe that there's been certainly no evidence of treatment for any psychological injury in this case. While it's obviously a betrayal of trust from a family member, I don't think that shows that professional treatment will be required at a certain point in the future either. So because of that lack of evidence, I would ask that remain at 0 points.
All right, thank you. OB4 is scored at, allows for a scoring of 10 guidelines points for serious psychological injury requiring professional treatment occurring to a victim. And the instructions say that we're to score 10 points if the serious psychological injury may require professional treatment. In making this determination, the fact that treatment has not been sought is not conclusive. And the case law interpreting OB4 focuses on the particular psychological harms suffered by a victim, not what we might expect a victim to suffer in certain types of cases. And in this matter, the forgery was of elderly family he was caring for, taking advantage of that situation. And the contents of the pre-sentence report described not just a sense of betrayal, which is very common in those cases, but beyond that, the psychological effects of this crime the victim has described how it's interfered with her grieving process for the loss of her husband. And then also has made her paranoid, as she described it. And I think given the effects that she has described and articulated in that written impact statement, I would agree that the preponderance of the evidence, there is evidence of a serious psychological injury that's been suffered by the victim, so I'd score OB4 at 10 points. So that increases the total OB from 30 to 45, is that right, Mr. Juliet?
Correct, in the OB level 4.
Level 4, and then the guidelines would be?
5 to 23.
5 to 23.
Judge, if I may?
Yeah.
I wasn't aware that there was going to be any scoring issues, and I made a strategic decision to not to file any challenges. I would object to the scoring of OB10, exploitation of vulnerable victim, as well as OB19, threat to security of the penal institution or the interference with court or justice.
Okay, so let's take them one at a time. OB10, go ahead.
Judge, that was scored at 10 points, which would require exploitation of a victim's physical disability, mental disability, youth or agedness, a domestic relationship, or the offender abusing his or her authority status. There's obviously a difference in age in this case between Mr. Guyette and the victim. However, I don't believe any exploitation occurred. There was an employment status, which was, or agreement, arrangement, etc., which was breached, which was a crime. However, Mr. Guyette did not use any agedness to exploit the victim. I don't believe there's any evidence of mental impairment or aging concerns that would rise to the level of exploiting someone. Thank you.
Mr. Juliet.
As best as I can tell, OB10 is scored at 10 points based on the behavior relating to the domestic relationship of the defendant. This was the defendant's wife's grandmother. He previously did hold some sort of agency relationship with her and her late husband. I believe he used that prior relationship, that prior domestic relationship, to then commit these crimes. So I believe 10 points is properly scored.
Yeah, I would agree based upon the relationship between the parties, and certainly there's exploitation here when somebody's, forging financial instruments to steal from them when they're in a position of trust. So I'll leave OB10. I think it's properly scored at 10 points. As to OB19, Mr. Scott.
Thank you, Your Honor. Mr. Guyette was assessed 10 points under OB19, which is interfering or attempting to interfere with the administration, of justice, or indirectly or directly violated a PPO, or the offender otherwise interfered with or attempted to interfere with the administration of justice. There's nothing in this case to support that in this scoring. Mr. Guyette wasn't on bond. He didn't have any pending cases. He didn't resist arrest. He didn't make false statements. His jailhouse conversation, when you read the transcript of it, is quite ambiguous. It's not as severe as described in the PSI, where I think the words used in the PSI were to urging the victim to withdraw a complaint or drop charges. Those weren't words used. It was like to the tone of check in with Marjorie, have her clear it up, and I don't think that rises to trying to interfere with the justice system. Thank you.
Okay, so looks like it's scored based on exactly that, a statement in the PSI after the defendant's arrest from the jail. The defendant made contact with his spouse to have her try and convince the victim to not pursue the matter and withdraw her complaints and statements. Mr. Juliet, your response, and the defense is arguing that that is not a fair characterization of those communications.
I have to disagree. I think that conduct falls squarely within OB19.
Is there a transcript of that communication?
If there's a transcript, I'm not aware of it. I don't know if it was transcribed or not.
Is there a verbatim description from any report?
I don't know if it's a verbatim description, but there is a description in one of the incident reports.
And you believe that that supports your position?
Yes, I do.
Okay. I guess if the parties want to, we have to resolve this by a mini evidentiary hearing here, but the rules of evidence don't apply and hearsay is allowed. So if you guys want to find that incident report, I'm happy to review its contents so that I can fairly adjudge the challenge. Do you want me to pass the case and take some other stuff while you guys sort out what sort of factual record you might want to establish on that?
Please.
I think that'd be awesome.
All right, so we'll pass the case so we can sort that out properly.
Thank you.
And we'll Mr. Clay, first to recall that case.
Yes.
Recall People v. Guyette, 24-6908. We were in the midst of addressing a defense challenge to OB-19.
Your Honor, just to correct the record, I did look at that 2015 marijuana that was dismissed due to insufficient evidence, so PRVs are properly scored. And if I can approach the clerk from argument People's proposed Exhibit 1 for OB-19, I've showed it to Mr. Seppi.
Any objection, Mr. Stepp?
No, I have reviewed that with counsel, no objection.
Okay, 1 is admitted. We'll do this then. Okay, based upon even the first page of the description of that, I can kind of see where the defense is coming from, but also where the prosecutor is coming from. I mean, Mr. Guyette from jail is communicating his hope that the complaining witness will clear things up and say that he had the authority to write the checks, or that she wrote them and signed them, or, whatever. Now, at the time that he's making those calls, I mean, if we just go back in time to that moment, if somebody is falsely accused of a crime, or there's a misunderstanding about a crime, and they are communicating, trying to clear up that misunderstanding, I think that might be something that lots of people would do. But Mr. Guyette is not someone who's falsely accused of these crimes. He's pled to them. So he stands convicted of 2 counts of forgery, and I have to sentence him today as though he's guilty of those counts of forgery. So in the context of somebody who has forged checks and then is communicating to get the complaining witness, the victim, to change the story and to say things to get them out of trouble, that does fall squarely within OB-19 for attempting to evade accountability for the crimes, which the case law does interpret as interfering with or attempting to interfere with the administration of justice. So I will sustain I will not sustain the defense of justice.
This is one of the biggest turning points in the entire sentencing hearing. Up until now, both sides have been fighting over guideline scoring. Not because the numbers look impressive, but because every point can influence the judge's sentencing options. After hearing arguments from both attorneys, the judge rejected the defense's challenge to OB-19 finding that the defendant's jail communications could reasonably be viewed as an attempt to interfere with the administration of justice. Combined with the earlier rulings on psychological harm and financial loss, the advisory guideline range has now increased from 0 to 17 months to 5 to 23 months. That's a significant shift before sentencing arguments even begin. But here's the question for you. Should post-arrest phone calls really carry this much weight during sentencing? Or do you think the defense had a valid argument? Let us know your thoughts in the comments, because from this point forward, every statement made by the defense and the defendant could influence the judge's final decision.
Objection to OV-19, we need it scrolled at 10 points. So I think that's resolved all of the challenges from both sides, resulting in both counts an advisory guideline range of 5 to 23 months. And Mr. Steffi, I did have an opportunity to review your sentencing memorandum, as well as several letters of support for Mr. Guyette. Is there anything you'd like to say on behalf of your client?
Thank you, Judge. I would. First, may I approach the bench? So the prosecutor, this is a receipt for payment, pre-sentence payment towards restitution.
Okay, very good.
In the amount of $10,500. Thank you.
Thank you. Okay, go ahead.
Thank you. Thanks, Judge. I appreciate your time reviewing my sentencing memorandum as well. And I guess I just need to object for the record to the sentencing challenges, which I was unaware of before today. I appreciate the opportunity to be heard on them. However, here, this case started out as a legitimate employment. Eddie was paid by George and Marjorie to be a caretaker, to take care of the property, as well as personal care of George. Typical, it seems, of the deceased, there was not a formal agreement. There was never any written employment agreement to terms of employment, salary, length. There's just nothing. So there's a lack of a record as to what was allowed and what was not allowed as relates to writing the checks in this case. So I want that to be clear. And I also want it to be very clear that Eddie did believe he did have permission from George to write checks. Now, that's something that we cannot verify because unfortunately George did pass away before the charges were filed in this case. Just as importantly, we're here to acknowledge that Eddie committed crimes beyond the allowable use of the checks. If the use was allowed at some point, he broke the law. I've been working with Eddie for quite a while now. He's been extremely remorseful for his behavior, as well as maybe even more for the fact that he blew up a loving family that he was really a part of and enjoyed that. And there's a lot of interconnection between the parties here. They're all related. He just feels really genuine remorse. And these cases are tough in a lot of ways, but with no contact orders and the related criminal consequences, Mr. Guyette wasn't able to make an apology to Marjorie. He's going to do that here today, and has wanted to for quite a while. And just that whole dynamic is just kind of just on display in the hallway while the case was passed. I was in the hallway talking to my client. Marjorie came out with a relative. You could just tell that both Marjorie and Eddie wanted to talk to each other and have a dialogue. That's not been possible till now in some senses. So I don't want the court to, I don't believe the court would attribute a lack of apology before sentencing against Eddie here. As part of my sentencing memorandum was under the assumption that the guidelines were 0 to 17. They are now 5 to 23. So some of that is irrelevant for Your Honor's consideration right now. However, this court is free to not impose incarceration, even though it is a straddle cell. I strongly urge Your Honor to consider a delay of sentence under MCL 771.1, which will allow the court to delay sentencing for up to a year. During that time, Eddie would be on probation. The court would be able to monitor him. It's a large amount of restitution here. It's $166,000. Cost us a change. The delay of sentence would allow Eddie to continue working his two jobs, one at the Manning Tire Shop as well as a local realty, and make progress in payment. We're here about 2 months after we pled guilty. We entered no contest pleas. Eddie was able to pay $10,500. He's not a rich guy, but he works really hard, and he's going to be able to make consistent payments and really wants to pay back Marjorie and anything to make amends. So I think he's a very good candidate for a delay. He only has one conviction as an adult. That's for operating while intoxicated as a young man. He doesn't have a violent history. He is active in his daughter's life, Salem, who we live with here, and his wife in Oregon. He's also active with two children who are teenagers now from a previous relationship. He's a valued husband as well. Volunteers his time in Sheboygan as a football and soccer coach. That's going to possibly change, of course, with having two felony convictions as of today, most likely. This is out of character for Eddie as an adult person. He doesn't have a history of this kind of thing. He's very sorry for what he has done. If Your Honor does not choose to impose a delay of sentence under statute, I'd ask Your Honor to consider holding a significant amount of jail time in abeyance in this case, as well as considering work release as part of both his rehabilitation. I would argue some of his punishment is paying back money in this case. And he won't be able to do that if he's in jail for a year, and he certainly won't be able to do that if he's sentenced to MDOC. So I would ask you to consider both the offense, of course, which we're here and have been here to admit responsibility to, as well as the background of Mr. Guyette and who he is, and his intentions, which he's proved by paying a substantial amount for someone of his station in life towards restitution today. So, Your Honor, I would ask you to consider some of those options that I've just spoken of, as well as contained in that memorandum of sentence. Thank you.
Thank you, Mr. Steffi. Mr. Guyette, you don't have to make a statement today, but it is allowed. Is there anything you want to tell me, sir?
I do have some. To the Honorable Court and to Marjorie, my name is Edward Guyette, and I appreciate the court taking the time to hear my statement today. I entered a no contest plea per my attorney's advice, but I want to take full responsibility for my actions and the pain that they caused. Marjorie, I want to speak to you directly and say I'm truly sorry for the stress and hardships this has caused.
And can you pause for a second? I think that she needs a little hearing assistance. We've got a lot of wind going on and it rattles that. Okay. I'm sorry that could you maybe
I'm sorry.
once she gets the hearing assistance in there, if you could restart. It sounded like there are things you wanted her to hear and she wasn't
sorry.
hearing them. No worries.
Start from the beginning when she gets something that takes a minute.
Does that sound better? Does that sound better, ma'am? Can you hear better? Okay. All right, go ahead. If you could please restart, Mr. Betty.
To the Honorable Court and to Marjorie, my name is Edward Guyette, and I appreciate the court taking the time to hear my statement today. I entered a no contest plea per my attorney's advice, but I want to take full responsibility for my actions and the pain that they have caused. Marjorie, I want to speak to you directly and say I'm truly sorry for the stress and hardship this has caused. While caring for George and Marjorie, I handled a wide range of responsibilities, assisting George with daily needs like bathing, dressing, medication, mobility, and general care. I also brought meals and tried to support him emotionally during difficult days. Over time, I was trusted to write checks for my weekly pay and expenses for George and Marjorie, which I understood to be part of my role. Looking back, I recognize that I could have handled certain aspects of that arrangement more clearly and responsibly. I acknowledge that the decisions I made, specifically around how those checks were written and for how much, led to confusion, concern, and ultimately the crimes I'm here to answer for today. I wish more than anything that we could have talked through this as a family before it reached this stage. George and Marjorie have always felt like true family to me. I spent a great deal of time in their home and on their farm, especially with George, and I valued that relationship. I know the fallout from this situation has impacted the family deeply. My wife no longer has a relationship with her relatives, and my children don't see their great-grandmother. That's been difficult for all of us. I'm not here to deny that mistakes were made. I thought in the beginning I was doing what I was instructed to, but in hindsight, I can clearly see I made bad decisions that were naive, foolish, and plain wrong. I take responsibility for my role in how things turned out, and I'm committed to working to repair that damage, personally, financially, and in my relationships when given the opportunity. I currently work at Manning's Tire in Sheboygan and also hold a real estate license. I plan to return to real estate with Berkshire and Sheboygan once this process is resolved. I will work my fingers to the bone to pay this money off as quickly as I am able to. I've been active in the community through coaching my son's soccer team for the last 4 years and doing my best to support my family and to lead by example. I respectfully ask the court for the opportunity to continue working, supporting my family, and making things right where I can. I can make steady payments towards the large amounts owed, and if I'm able to continue working my jobs, I do not want to delay making this right. I'm ready to show through my actions that I take this matter seriously and that I'm committed to moving forward in a positive, responsible way. Marjorie, again, I'm so sorry for everything that this has brought on you, and I pray someday that I can fix what I've broken. Thank you.
Thank you, sir. Mr. Juliet, any recommendations?
Would like to address the board.
Okay. Good afternoon, ma'am. You can stand at that podium right there and tell me anything you'd like me to know.
Right here?
Yeah.
Okay.
Yes.
This past year, my life has been filled with the pain that arrived when we realized the people George and I cared for did not feel the same way about us. My heart was broken when I realized that George and I were being used and taken advantage of by Eddie while he was helping himself to George's money. He was doing so all while knowing if he needed financial help, he could have just asked for it. We cared deeply for Eddie and his kids. We helped them with anything they ever needed. The house they lived in was brought by us. The cars were drove because of us, and there's nothing we wouldn't have done for them. Every day since we discovered he was stealing, I have not been able to rest my mind. I try my hardest to push away the thoughts of what they did, but it seems that the betrayal is all I can think about. It has been such a long year, and I have prayed every day that this would be over soon, so I can move on from this chapter and try to enjoy what is left of my retirement years. No one's retirement should be filled with so many lawyers, advisors, subpoenas, and police station visits. Because of his actions, I am less trusting. I have had to go through so much stress and make really hard decisions because of him. I am paranoid now. I smile less and I cry more. Over the last year, I have lost my husband, my son, 3 lifelong pets, 2 grandchildren, and 3 great-grandkids, and nearly $200,000. I have been so stressed, sad, and depressed, and I never would have thought I would have to be on antidepressants to help me cope with my day-to-day life that was once so great. I am ready to complete this chapter of my life and move on. While all this court drama has been hanging over my head the last year, I feel that I have not been able to properly grieve the loss of all those things, but especially of my husband. I know that grief is a slow and delicate process, but since my mind has been so occupied with Eddie, my grieving progress has been interrupted. I hope soon I am able to start that process over and move forward in my life without George. By the end of George's life, I noted the care we were getting from Eddie was not as consistent as it once was. And every time I called Eddie to ask for his help, I felt like I was bothering him. I felt like George and I were a nuisance. I now wonder if he only kept showing up because he cared about getting more money, not because he cared about George's well-being. George quite literally trusted Eddie with his life, and he was taken advantage of. I am grateful that my husband was not here to see what they had done. George would not have been able to handle this situation in a fragile and vulnerable state. He was an amazing entrepreneur his life, and he worked so hard for the money that Eddie had stolen. If he had not been caught, I wonder if he would have kept taking money until there was nothing more to take from us. Eddie's actions have told me loud and clear that George and I were just checks to him, not the grandparents that we thought we were. I'm ready to move on from this chapter of my life that should have never happened in the first place. I believe I will be happier, less stressed, less paranoid, and more relaxed now that this criminal case is at its end. But most importantly, I believe I'll now be able to properly grieve the loss of George. Thank you.
Thank you, ma'am. Mr. Juliet, recommendations?
Your Honor, the advisory guidelines are 5 to 23 months. There's a recommendation for 1 year in jail, 3 years probation. That was recommended under the previously scored 0 to 17 guidelines. I'll first start with, I guess I'm going to object to the 771 delay of sentence. This started out as a 69 count felony complaint that charged forgery over almost a year, and to the tune of $166,000 at least. So I don't think this is an appropriate case for a delay of sentence. In the defendant's allocution, I heard a lot about mistakes, and at some point, I mean, I agree, at some point there was some sort of agency relationship where I do believe that he was helping out, but obviously that wasn't the case for very long. Given the sheer amount of money that was stolen over the length of time, I think there has to be some incarceration here. So the guidelines being 5 to 23, a sentence within those guidelines is presumptively proportionate. I would ask for at least a middle to top end of those guideline sentence.
Thank you. Mr. Guyette, if you'd please stand for the court sentence. Well, Mr. Guyette, these are always unfortunate cases where people are then taken advantage of, and especially by people that they thought they could trust. It sounds as though the involvement that you had with them was did involve some financial things back and forth that were legitimate, but then things that were not. But that's what you need to understand, is that's not all that uncommon. For example, when people embezzle from an employer, they have a relationship with their employer, and they show up and do a lot of good work, but they also steal. So just because you're providing some care and doing some things for them legitimately doesn't really seem like a major mitigating factor to me, because it's present in so many of these types of cases that the betrayal usually comes from someone close. That's what makes it a betrayal. You're 34, you have no prior felony convictions. You've made a significant payment toward the restitution. Your remorse does seem genuine. So you know, your attorney has made some really excellent. He's positioned the case excellently for you, to the extent that, you know, I thought long and hard about maybe even the statute would allow delaying the case for up to a year to see how you do on a probationary term before we decide what sentence you should get. And I gave that a lot of thought, more thought than I thought. At first, when I saw that request, I sort of chuckled, to be honest, you know, because it was a pretty bold request. But as I got into the details of the sentencing memoranda, I saw exactly where it was coming from, and it's not an unreasonable request. So it did give me pause. The reason why I'm not going to do that today is a lot of it is the victim comes here today, Ms. Galbraith, says, gee, this has been really a stressful thing to go on. I'm glad this is over. If I delay the sentence for a year, it's not over. We'll be back in a year and do all this again. And I'm not going to do that to her. So I'm not going to follow your attorney's recommendation for a delay. I'm not sending you to prison today. So the guidelines changed a little bit, and that probably gives you a lot of nervousness standing there knowing you could go to prison, but you're not going to prison today. I don't think that when I consider the circumstances of the offense, maybe, but when I consider the circumstances of this offender, prison would not be what I'd want to do here. So taking all those things into account, I am going to place you on probation for 36 months as recommended. It'll be subject to the terms and conditions of the pre-sentence report. I want to highlight some of them. Mr. Juliet, do you have any opinion or input from Ms. Galbraith about that no contact continuing through the probationary order, or whether she'd want that lifted at this time? I mean, I could just leave it in place, and then if she changes her mind, you can let the probation agent know. They can always submit a change.
Can we just leave it in place for now?
Okay. So you can't have any contact with Ms. Galbraith on probation. Okay.
I just want her to go see her granddaughter if she wants. I don't want to.
Well, you can't have any contact with her.
That's fine. I just don't want to be stopped. I don't want that to be a reason.
Right. And you'll have a probation agent that can help you navigate the details of that. And if Ms. Galbraith changes her mind about that, she can let the prosecutor know, they can let probation know, and they can submit a request to me to change the terms of your probation. You have to seek and maintain legitimate employment for at least 30 hours a week. Pay restitution of $166,000. I mean, I know that you did make a payment today, but the judge will have to put the full amount in because that's what's ordered. The crime victims assessment of $130, court costs of $350, state cost of $136. Comply with DNA testing and pay a $60 fee, and there's a monthly supervision fee to the Department of Corrections. And I think the amount at question was really driving the recommendation as well. I think on the whole, I'll order that you serve 9 months in the Sheboygan County Jail. Give you credit for 1 day previously served. Now, Mr. Juliet, people have any position with regard to work release?
I would leave it to the Sheriff's Department's discretion.
Okay, so I'll approve Mr. Guyette for the jail's work release program if he complies, if they find him eligible for that and he complies with their program for up to 40 hours a week. That is a sentence within the advisory guidelines. I think it is proportionate to the circumstances of the crime and the offender. Mr. Guyette, you need to contact your probation agent within 24 hours of your release. And if you wanted to appeal, you can file an application to the Court of Appeals. If you wanted a lawyer and qualified, we could appoint one for you, but you'd have to make that request within 6 months. We're going to hand you some paperwork about the appeal, ask you to initial one copy so we have a record we gave it to you. The other one is for you to fill out if you want to appeal. You also may petition for early discharge from probation at the halfway point. We're going to give you a piece of paper explaining that process and those rights. Do you have any questions for me, sir?
Like I said, I just want to make it right.
Okay, well, you can do that going forward, and you've made a good step in that regard today, so keep it up.
Thank you.
All right, Mr. Voida.
What a remarkable sentencing hearing from start to finish. The court carefully examined every guideline objection before ultimately increasing the advisory sentencing range based on the financial loss, the psychological impact on the victim, and the finding that the defendant attempted to interfere with the administration of justice. Although the prosecution argued for incarceration and the defense requested a delayed sentence that would allow continued employment and restitution payments, the judge ultimately chose a middle ground approach. The defendant was sentenced to 36 months of probation, ordered to pay approximately $166,000 in restitution, serve 9 months in county jail with eligibility for work release if approved, maintain employment, and comply with strict probation conditions, including a no-contact order with the victim. Throughout the hearing, the judge acknowledged the defendant's remorse, lack of prior felony convictions, and efforts toward restitution, while also emphasizing the devastating breach of trust and lasting emotional harm suffered by the victim. This case serves as a powerful reminder that financial crimes involving vulnerable victims often carry consequences that extend far beyond money, affecting families, trust, and emotional well-being for years to come. Now we'd love to hear from you. Do you believe the judge reached the right balance between accountability and rehabilitation? Or should the sentence have been either harsher or more lenient? Share your opinion respectfully in the comments below. And if you found this courtroom breakdown informative, make sure to hit that like button, subscribe to the channel, and turn on notifications so you never miss our latest courtroom analysis and legal breakdowns. Thanks for watching, and we'll see you in the next case.